There is one way to get permanent residency here in Canada without the express entry system or the provincial nominee program. H&C, or Humanitarian and Compassionate Application, is a route that not many people know about, but those who do often struggle understanding how it really works. I made this video with one of our most experienced lawyers to cover what is H&C, challenges with H&C, what happens if rejected, successful H&C applications, and finally, citizens of what countries can rely on H&C. Make sure you're subscribed, like this video, and let's start from introducing our lawyer.
I'm the principal lawyer at Cruiseford Law Firm. We're based in Toronto, but we, of course, work federally. We have 9 lawyers, and we do A to Z immigration, meaning full service from visitor visa to federal court to refugee claims, and of course, humanitarian claims. And the one thing that I always say, we treat all our clients the same way we want to be treated.
And 20 years of experience doesn't go unnoticed. When you are applying to get permanent residency, you've already gone through so much, invested so much in this, that I say it's expensive to be cheap. You want to go with people you can trust and those who have enough experience to get you there. Let's talk about something very important.
When I look at numbers, I say, okay, let's say you have 8,000 a target, or let's say the high range of 12,000, but you have 20,000 amazing applications. Really, what's going to happen, right? So I always say, when somebody is eligible for a program and has a good chance with the program, nothing to lose, you got to do.
To sum up the following information, you need to understand the government immigration targets in numbers and pay attention to the drop in H&C applications in the following 2 years. From almost 14,000 in 2024 to only 8,000 in 2025 and 2026. This signals that it may become more competitive in the years to come. Now let's answer, what is H&C?
So it's exactly as you mentioned, it's a humanitarian or compassionate application to remain in Canada, so it can only be done inland. But before we even talk about, as we say, H or C, but everybody calls it H&C, so we're gonna use the common term. Let's discuss when to use it. I think that's the first question. So when we get, let's say, anybody came as a student, went to school, graduated, doing the PGWP, but for whatever reason, they don't have enough points under the express entry, or they don't qualify under a provincial program, then they always come to us and really say, please find something, okay? Like we can't go back. It's very tough for us to go back. It's very hard for us to go back. We invested so much. We're established here. It's going to be a disaster for my family overseas if I go back, and everybody got their own reasons. And that's when we start looking at all the options. And one of the options, which is not necessarily the first option we look at, and we'll discuss why in a second, is the humanitarian or compassionate grounds application. So it's essentially an application that you can use, or the applicant can use, whatever factors they believe will show that they have a hardship of applying for permanent residence from outside of Canada. So it can be a range. It's so unique. It's one of those cases, it's not a point system. It's not, okay, I speak English, I'm working in IT, I'm fine. It doesn't work this way. It's really individualized. It's really specific. And there are many factors, and here you have few of them. For, of course, establishment in Canada. How long have you been here? Can you support yourself? Do you have any children, whether Canadian or not? How old are the children? Are there any medical issues? Are there any criminal issues? Is there any specific risk or hardship in the home country? Maybe a case of family reunification. So I'll give you an example. As many people know, to sponsor parents or grandparents right now, it's very difficult. Why? Because they have a lottery system which is kind of closed since 2020, and we have cases that the Canadian doesn't have anybody in Canada, or maybe their parents are alone in the home country and they came for a visit, but they really need them to stay. So right now, humanitarian is used as the tool for that. So there are many factors. It's very important. I always tell clients, this is not a point system. It's not an absolute system. You really have to talk to a specialist.
So if you're part of the community, you work, pay taxes, standard PR streams are out of reach, while going back is not an option, H&C can be a great pathway for you, but it's not that easy. Ronan, tell us about why this is a difficult application to make.
Okay, and the first thing I say that in the past, because as you mentioned, I've been doing this for a long time, they used to have interviews on humanitarian cases. And I loved interviews. It wasn't mandatory, it wasn't in any case. But whenever a case was referred for an interview, we knew that we have a very good chance. And there's a reason, because the officer could see the applicant, could speak to the applicant. Usually it was in a small room. It was not too adversarial, and the applicant could convey why they think they have a good case. Now, unfortunately, I'm trying to think. I'm sure they can still interview, but I can't even think of an interview that we had on a humanitarian, I would say even for more than 10 years, at least. So really the paper has to talk to the officer. And this is not easy. To have paper talk to the officer, I know it kind of maybe makes no sense. Maybe it sounds hilarious, but it really isn't. The officer is going to read the application. It's not going to see the applicant. So when I see the clients in the office, or when we see the clients in the office, sometimes we have tears. I'm being very honest. Like it happens, but tears whether on our end or on the applicant. Here, just we don't have that option. We don't have the chance. So the evidence and the documents, and most importantly, or just as important, the submissions have to be very, very carefully prepared, carefully made. And, I've been to one, so we as lawyers, we have an annual, we have a few sessions under the CBA. And I remember one of the officers for immigration and one of the lawyers on one of the panels said that that's the one that in immigration, court aside, hearings aside, it's the most lawyering. This is not just filling a form. Yes, there are forms, but the forms are really the tip of the iceberg for those applications. That's when we really get to do our lawyering. Your third point is critical. We always tell clients, this is not a point system. Okay, so it's not your age check, your education check, language check. It's so discretionary, okay, that we can send the same application, honestly, to 4 different officers and get 4 different decisions. Like 1 can say yes, 3 no, 4 can say yes, 0 no, 3 can say yes, 1 no. There's really, really the discretion factor here is very big. And it's not common that we get a lot of decisions at the same time, but about, I would say 6 months ago, we got about 8 in a span of 2-3 days. I can tell out of the 8, 6 were approved, 2 they refused, okay? And if I would have to rank them, the 2 that got refused, I think had way better cases than the other 6.
What about working in the meantime? Let's say you submit an H&C application, but your work permit is expiring in 6 months. Technically, you can apply for a work permit extension once the application reaches the first stage, which can take many months.
Unlike refugee claims, it does not give somebody status. So let's say if your status expires in 3 months and this takes 18 to 24 months, you have to worry about what you do in the meantime. And that also what makes it complex. Is it going to be a TRP application? Maybe the employer wants to do LMIA. There are other circumstances that people don't have status for many years.
A refusal can be a nightmare for many people, but when you have a legal representative, there are many ways to reverse that.
Lawyers will know there are many cases and many case law in the federal court about humanitarian or compassionate ground applications. So when anybody prepares an application, whether it's a lawyer, a consultant, or whatever, they need to be ready. And every application, even if we think there's great chance, okay, we prepare it with the knowledge that, maybe an officer will refuse and it's going to go to the federal court. So that's the first thing. So when a case gets refused, what we typically do, okay, we would, just like the 2 I gave you an example, we would file a notice with the federal court. We're going to get the reasons in about 30 to 40 days. Now, we have, or anybody, for an inland refusal, you have 15 days to file the notice. So that's got to be done right away. It stops the clock. Once we get the reasons, we can look at the reasons, of course. We look if we submitted it. We look at what we submitted. and then we decide, okay, let's continue with the court, or you know what, maybe it's better to refile. Without tapping yourself on the shoulder, because nobody's perfect and we're not the officer, we're not God. It's very uncommon. I can't even think of a case we did and we saw the reasons, we would decide to refile. Like that, we'll just continue with the court. But let's say we get from people who got refused, and if the consultant or the lawyer did a good job, we'll continue with the court. But sometimes, based on the reason, we can see that some documents maybe could have been presented better, or maybe they were not presented at all. Then we'll tell people to refile. And the first question that I get when we recommend that is, do I have to pay the government fees again? The answer is yes. Do I have to wait the same time again? Unfortunately, the legal answer, yes. Now, practically, sometimes on refiling, we do see a faster answer, okay? But the legal answer, it's starting again, you're back in the queue.
Yeah, so that's why it's important to put together a strong application from the start.
Absolutely. That doesn't matter who people use, that's especially on humanitarian cases.
All right, so now let's talk about successful applications. From your experience, you've already outlined the first one. It's individuals who've been here for at least 5 years, they're established, with or without kids. What about the other two, the best interest of the child or family reunification? Can you talk more about it?
Yeah, so those cases, and I know we mentioned it at the outset, are very, very specific. Humanitarian cases, this is not a point system. I know we said it 100 times already. I'll say it one more time. They have to be they're very unique to the individual. So I'll give you an example. Typically, yes, rule of thumb, 5 years, but we had a case, okay, and that's the best interest of the child. Somebody came from abroad. Not gonna mention the country, doesn't really matter because there's no impact to the source country in that case. And our clients, two nephews, they were Canadians, and they had, unfortunately, disabilities. And when she came here, she said, listen, I cannot leave I have to help my sister who's Canadian. We cannot leave my nephews alone like that. And she got really attached, of course, to the nephews and vice versa. So we filed the application. I think it was about 5-6 months after she came to Canada. It was approved. It was one of those that went very fast. Until today, I don't know why. I can tell you we had very good evidence, especially from the Canadian doctor. The Canadian doctor wrote that the kids are so attached to their aunt, who was in Canada as a visitor at that time, and if she has to leave, you're going to devastate the children. Mm-hmm. And he wrote, it wasn't a long letter, like it wasn't a big story or medical. It was a medical doctor, a big hospital. And he wrote really, as that I called the doctor and I said, wow, like he said, no, I wrote from my heart. It's not like somebody told me to write this. That's what I believe. Like if this lady goes home, you kill the kids. That's the words the doctor used with me.
What about kids with autism? There are many of those these days. Is that a good reason to say that in the home country, the medical treatment or the societal approach to such individuals is far worse than in Canada? Is that a good reason to stay in Canada?
That's definitely a good reason, but just a general, every case, as I said, the paper needs to talk. So we find out that it's okay, you say, the client says, we say, when we get letters from medical practitioners, doctors in particular, there's a lot of weight for this, especially when it comes to children. But to answer your question, yeah, sure, autism is definitely, Canada has, fortunately, a very good system and very good support structure. And if it's not available in the home country or the source country, yeah, that's definitely a hardship if somebody has to leave Canada.
Well, let's talk about citizens of what countries can rely on this application. It's important that we state before we begin talking about this that all these country flags you see on the screen are just examples, and it does not guarantee that if you come from, let's say, Ukraine, and because there's a war happening right now, you will be granted PR on H&C grounds. Ronan, let's talk about good examples. So let's start from the letter. Let's say that you are an African national, let's say you're from Cameroon or from Nigeria, you're gay or lesbian, and these countries criminalized such individuals. So going back home would be life-threatening. Is that a good case?
Yeah, so it's definitely a good case. So we always say we divide humanitarian cases to what's inside hardship to leave Canada and then hardship at the home country. So that obviously will go into that, and those are good cases. But as always, credibility and the evidence is very, very important here.
So with this example, can a gay person from Nigeria claim that they need to get PR based on H&C because being gay is criminalized? Is that enough of an evidence?
That alone, I don't think that's enough alone. Okay, but it depends on the circumstances and the experience of that person. Like, was he targeted, or did he have other issues? Did they no jobs? Right, so it's really case by case specific. The question, like one factor and that's gonna do it, no, unfortunately, it doesn't work this way.
Perhaps it's some threats from back home. Maybe somebody in the family found out and then they threaten them with a text, with a call, with a letter. Does that count?
Yeah, again, it's one of the fact. Like, so if somebody came to our office with that, would we take a case like that, knowing, of course, more details? Yes, but can we guarantee that, hey, you have this and an officer is going to approve you? No. And at the end of the day, you have to look at the totality of the evidence.
So up here we have Ukraine, we have Palestine, obviously we have Myanmar. These countries have an active war happening right now. Would somebody who, let's say, moved here from Ukraine a few years ago, whose home was destroyed, let's say it's Eastern Ukraine, would they qualify?
Yeah, they will qualify, but I can tell we have Ukrainian cases, okay, and the success we didn't, honestly submit one. Okay, there's war in Ukraine, that's it. No. So again, we look at when they came to Canada. Are they working? Are they established? Are they involved in the community? And then that's only one of the factors. But to say that there's a war in some region of the world and that will grant you permanent residence, it's not accurate.
If you'd like to work with us on your future here in Canada, there are 2 steps. Step 1, legal consultation to discuss your case. And step 2, we start working on your file. I believe that immigrants are future leaders driving Canada forward. If you'd like to invest in your future, click on the link in the description. Learn more about our agency service and its cost. And finally, book a time to discuss your specific case. Also, I'd like to invite you to a webinar we're hosting soon to discuss how to get permanent residency now. It's free to attend, the link will be in the description to the video. Thank you for watching, like this video, and I'll see you in the next one.